So recently a client asked me an interesting question, and that is, what takes priority or what takes precedence, a deed or a will? In order to understand the answer to this question, let's first discuss what each instrument is. A deed is a written instrument which conveys title to real estate from one party to another. Now, in general, a deed is going to have elements. And these elements are, it's going to name the parties that are involved, the grantor and the grantee, the person transferring title, and the person receiving title. It's also going to contain consideration. Now, consideration can take the form of money, which it usually does, or it can take the form of something of value, like a promise. But in general, on a deed, you can look at the sale price. That'll be stated. The deed is also going to contain a description of the real estate being transferred. In Massachusetts, there are one of two ways that a piece of property can be described. It can be described with meets and bounds, which basically is a legal description of the perimeter of the lot of real estate being sold. Or it can be a reference to a plan, so a lot on a plan or a plot on a plan of land, which has been recorded at the Registry of Deeds. Now, in Massachusetts, a deed does not need to be recorded at the Registry of Deeds in order to be valid. All the deed needs is a signature of the grantor or grantors. Now, I've included some links below for some of my prior videos talking about deeds and the Registry of Deeds and what that's all about. So make sure that you check that out. Now, what's a will? Well, a will is a written instrument which expresses a person's intent on how they want their assets distributed at the time of their passing. Now, in general, the elements of a will, the will must be in writing. It must be signed by a person over the age of 18 and of sound mind. A will is also going to be witnessed, we say, by two disinterested parties. Massachusetts, the rules change just a little bit with respect to parties that are interested that may witness the will, but in general we recommend that the parties that witness a will are not involved in the estate. Wills are typically notarized as well, and they must once again be executed. So those are elements of a will. So now, what takes priority, the deed or the will? Well, folks, the short answer to this question is the deed takes priority over the will in general, because the way you must look at this is the deed is going to express the current intent of somebody who's transferring title. But there are instances now where a deed can be challenged. I'll give you an example. So mom holds title to a piece of real estate and she has two daughters. Mom executes a new deed, which she puts herself on there as a life tenant, and she puts one of her daughters on title with her. So mom has the right to live on the property and do everything while she's alive. And upon her passing, it would go to her daughter, one of her daughters. Now, mom, after signing this deed, or even before signing this deed, executes a will properly, in which she leaves the same piece of real estate to both her daughters equally. Then mom passes away. Now, by operational law, mom had a life estate on the property, if you remember in our example, and she only put one of her daughters on there. Mom passes away, her daughter receives title to real estate and receives it alone, 100%. Now, once mom's will is introduced into the probate court, the second daughter certainly has the ability to question the deed, challenge the deed, and say that maybe mom wasn't competent, or maybe mom didn't intend for just one daughter to receive title to the real estate. That mom actually intended both daughters, but that she put one daughter on the deed as a matter of convenience. And that could cause a trial where there's a question of fact as to what mom's true intent was. So there is an instance, or this is an instance, where a will could overpower or overrule a deed if it's determined by the court, by a judge, that the deed actually was a matter of convenience, or maybe mom was under duress. So once again, the short answer is the deed will take priority over a will unless it's shown otherwise in a court of law. Now, make sure that you subscribe to my channel below on the lower right-hand corner. Check out the links that I have included in the description for prior videos talking about some of these concepts. And some of my other videos will be appearing here. Make sure that you check them out. There'll be also a list of other videos from the past. Dave Ceruolo, CeruoloLaw.com.